Hi, in this video we shall be reviewing the RTE Act pertaining to the educational system of the Indian Constitution. The RTE Act or the Right to Education Act was established under Article 21A as part of the 86th Amendment of the Constitution Act of India. This was an act established in fact to eradicate all sorts of discrimination. So, what are the strengths and weaknesses of these two sections? The law mandates schools to admit children irrespective of their caste, creed, religion, sex, and socioeconomic background. This is its strength. However, the interpretation and implementation of Section 17.2 becomes a challenge and a bone of contention when schools look at applying Article 15.4, which stipulates that schools can make special provisions for the advancement of any socially and educationally backward classes. This creates a loophole wherein schools can choose to apply Section 15.4 in lieu of Section 17.2 and therefore ask parents to submit caste certificates of their children if they belong to backward classes or scheduled castes or scheduled tribes. The categorizing starts here and so does the problem. So is this only a problem of modern India? In fact not. Let's look at the historical perspective of this. While the Britishers brought about social reforms through the Caste Disabilities Removal Act in 1850, which aimed at abolishing the concept of untouchability, it also ushered in the Scheduled Caste Order in 1936, which required listing of all castes and legalizing the system of castes, which were until then only a matter of culture. So, was this a blessing in disguise or a curse in disguise? Multiple amendments of the constitution of post independent India paved way for the introduction of the caste based quota system in educational institutions by certain state governments. The law was unclear unto itself as each state interpreted it in its own way, and the courts of law interpreted them in a different way. So, where do we stand today? We stand today at a paradoxical crossroad where the Constitution strives to promote equality but can do it only through segregation and categorization of the masses, wherein no party claims to be 100% content with any of the provisions of Articles 15 and 17. The ramifications of this paradox is felt in the day-to-day functioning of schools, wherein Article 17.1 is being disregarded and students continue to receive corporal punishments and face mental harassment. These two reports clearly indicate that verbal and physical harassment and disregard of Section 17.1 and 2 continue to haunt schools in India. Another interesting alternative perspective is offered by the statistical study, which shows how people within the marginalized communities practice discrimination and untouchability. As for schools, it becomes a tightrope walk between sections 15 and 17.2, and they end up facing criticism and finding themselves in legal controversies. This means governments could consider stopping the issuing of caste certificates. Schools must be ordered not to collect or ask for caste certificates while admitting a child. Although physical punishments and mental harassment may continue to haunt schools for other reasons such as socioeconomic background of students, the amendment of Section 17.2 can certainly plug in some loopholes in future implementation of Section 17.1.